Welcome to the Explainer. Today, we're talking about a document that's going to define your legacy, your last will and testament. And it's about so much more than just money. It's really about protecting the people you love and making sure your final wishes are carried out.
Let's just kick things off with a number that is, well, it's kind of shocking. In South Africa, a massive 85% of people do not have a valid will. That means the huge majority of us are pretty much leaving the fate of everything we've worked for up to chance. And that can create a whole world of problems for the people we leave behind.
So in this explainer, we're going to break it all down. We'll walk you through what a will actually is, why it's so incredibly important to have one, how often you should be updating it, and of course, the key steps that make it legally rock solid. Okay, so what is a will, really? To get how it works, we just need to get on the same page with three core ideas. First up, the will itself. The best way to think of it is as your final instruction manual. It's your official, legally binding declaration that tells everybody exactly how you want your stuff handled. It's your voice preserved in writing. Next, we have your estate. And this is a big one. It's not just your assets, your house, your car, your savings. It also includes your liabilities, any debts you owe. A will basically decides how the final balance of everything you own and everything you owe gets divvied up. And finally, the executor. This is the person, or maybe an institution like a bank, that you put in charge. They're the project manager for your estate. They have the legal duty to gather all your assets, pay off your debts, and make sure your heirs get what you left for them, exactly as you wanted. It's a role of huge trust. So now that we've got the terms down, let's get to the real heart of it. Why is having a will so absolutely non-negotiable? Well, it's because when you pass away, your legacy is going to go down one of two very, very different paths. See, if you don't have a will, you're said to have died intestate. And in that situation, you don't get a say anymore. Instead, the South African government steps in with this very rigid one-size-fits-all legal formula to carve up your estate. And when you look at it side by side, wow, the difference is just night and day. With a will, you're in the driver's seat. Your wishes matter, you decide who takes care of your kids, and you pick an executor you trust. Without one, the state's formula takes over, which can cause family fights, huge delays, and maybe worst of all, leave the care of your children in question. So it's pretty clear a will is essential. But here's the thing, it's not a set it and forget it kind of document. Your will is like a snapshot of your life, and as your life changes, your will needs to change right along with it. So, when should you pull it out of the drawer for a checkup? For sure after any big life event. Getting married, getting divorced, having a baby, if someone named in the will passes away, or if you buy or sell something major like a house. These are all huge triggers. And even if nothing big happens, it's just smart to take a look every 3 to 5 years anyway. But there's one life event that comes with a very specific, very strict countdown timer in South African law, and that's divorce. And ignoring this one can have some massive, unintended consequences. The number you absolutely have to remember is 3 months. So, the Wills Act gives you a 3-month grace period after your divorce is final. If you were to pass away within that little window, the law automatically reads your will as if your ex-spouse had already passed away, which means they can't inherit. It's kind of a built-in protection during a really tough time. But here is the massive catch. Once that 3-month clock runs out, the whole assumption flips. If you haven't updated your will by then, the law presumes that you still want your ex-spouse to inherit whatever you left them. Your inaction could literally send your legacy somewhere you never intended it to go. Okay, so you're ready to create a will, or maybe just update your old one. What are the absolute must-haves that you need to make sure are in there? This is basically your core checklist. You got to clearly identify yourself, you have to cancel out any old wills and name your executor. You have to be crystal clear about who your heirs are and what each of them gets. And listen, for any parent, this is so important. You have to appoint a guardian for your minor children. If you don't, the state is going to decide for you. All right, last but not least, how do you make sure this document will actually stand up in court? Because you can have the most perfect will in the world, but if you don't follow the legal rules to the letter, it can be thrown out. And the Wills Act is incredibly strict about this. First, it has to be in writing. Second, you have to sign every single page and then again right at the very end. Third, 2 witnesses have to be in the room and watch you sign at the same time. And finally, those witnesses have to sign it in front of you and in front of each other. You can't skip a single step. Now, the law also has this really smart built-in protection against anyone trying to influence you. It's a critical rule about who can be your witness. Neither the witness nor their spouse can get anything from your will. If they're named as a beneficiary, they're automatically disqualified from inheriting. This makes sure your witnesses are totally neutral. Creating a valid, up-to-date will is one of the most powerful acts of care you can do for the people you love. It swaps out uncertainty for clarity, it helps prevent arguments, and it guarantees your final wishes are honored. So the real question isn't just about whether you have a will, it's about whether you have a plan. Is yours in place?